All rise. First District Court of Appeals is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the afternoon docket, Smith versus Borg Warner. Is the appellate ready to proceed? You may.
May it please the court, Matthew Gutierrez on behalf of the appellant. Your Honors, I'd like to reserve 5 minutes for rebuttal. So, as we've explained in our briefing, the trial court below committed 2 errors. The first error is substantive and the second error is procedural, but both errors are reversible independently. And if the court doesn't have any questions about the facts, I'll jump right into the argument. So the first error that the trial court made is a substantive error. The trial court erroneously determined that the plaintiff failed to provide any evidence establishing or supporting a finding of fact by the jury that Mrs. Smith, the decedent in this case, was ever exposed to asbestos from brakes that were manufactured by Carlisle. And this is referred to in the case law as a product identification requirement. But in this case, it's somewhat of a misnomer, and I'll explain why. So typically, in asbestos product liability cases, a threshold requirement, a foundational requirement for establishing causation against a defendant is, of course, establishing that the decedent was at some point exposed to a product, an asbestos-containing product manufactured by the defendant. In this case, the defendant is Carlisle. Typically, the burden, this threshold burden, is satisfied by the victim or a victim's coworker, quote-unquote, identifying the product. And typically it's Mrs. Smith worked with ABC Widget, and we look on the label of ABC Widget, and it says manufactured by ABC Company, and then we know that we have the right manufacturer. In this case, there was one extra step. The defendant, Carlisle, the product at issue did not have Carlisle labeling. The product was labeled Mac. So it's James Smith, Jr., who is the decedent's son, testified at his deposition that Mrs. Smith was exposed to Mac brakes. And Mac didn't manufacture its own brakes. So unfortunately, in this case, identifying the product was not sufficient. We had to go a step further and ask or inquire of Mac who provided the brakes to Mac. The sole basis of Carlisle's summary judgment in this case, which was a 3-page summary judgment, was that no witness said the word Carlisle, and therefore Carlisle was entitled to summary judgment. Of course, as we've explained, that is not the inquiry in this case. That is not sufficient to obtain summary judgment in this case because no witness was able to say the word Carlisle because they would have had no way of knowing that Carlisle was the manufacturer. So we had to go to Mac and determine from Mac who sold the brakes to Mac during the time in question. We asked Mac. Mac, through 3 witnesses, uniformly through those 3 different witnesses and through interrogatory statements, stated, "We don't know." Mac said, "We have numerous authorized suppliers during a 30-plus year time period, but we don't know whether any of them or when any of them may have actually supplied brakes to Mac."
Counsel, didn't Mr. Krause, who is one of Mack Truck's corporate representatives, testify that, during the relevant time period, 1974, which was one of the years that it had been narrowed down to, that there were at least 3 or 4
Yes.
suppliers?
He used the word suppliers, and that's an important word that he used. That is a noun. That is not a verb. So Mr. Krause, like all of the other witnesses, testified that during the specific year 1974, Mac had 3 authorized suppliers, which is consistent with the other witness testimony on this issue. But one's status as an authorized supplier is not evidence of actual sales. So being an authorized supplier does not mean that you actually sold any products during that time period. But even liberally construing that evidence in favor of Carlisle, which of course is the opposite of what the court is supposed to do on a motion for summary judgment, even liberally construing that statement in favor of Carlisle, it still doesn't negate our showing for one simple reason. Even if that were the case in 1974, what about 1975, 1976, 1977, 1978, and 1979? Carlisle definitively testified that it sold asbestos-containing brakes to Mac from 1974 to 1979, and I submit there is no other evidence in this record of any actual sales to Mac during that pertinent time period. But even assuming the court concludes that there is evidence of sales in 1974, there's still no evidence of sales in 1975, from 1975 to 1979, if that answers the court's question. So this goes into a broader issue that Carlisle raised, which is the idea that numerous authorized suppliers existed to Mac. Mac had about a dozen authorized suppliers, and therefore, Carlisle argues that it was entirely speculative whether the brakes at issue were Carlisle's brakes or the brakes at issue were from one of the other authorized suppliers. Again, the issue with that argument is that it assumes incorrectly that there's evidence, or it suggests incorrectly that there's evidence that the 12 suppliers were simultaneously providing brakes to Mac the entire time period. Again, the record simply does not support that. The other witness that they state shows actual sales to Mac during the pertinent time period is Joel Cohen. Joel Cohen, they suggest, or they imply that he testified that Bendix, for a 30-year period, continuously supplied brakes to Mac. But if you read Mr. Cohen's testimony, it's actually to the contrary. They asked him, over this 30-year period, do you have any evidence of Bendix brakes being sold to Mac? He said, quote, there's a very limited number of sales that occurred sometime during that 30-year period. I submit it would be entirely speculative for the jury to conclude that any Bendix brakes were sold between the period 1974 to 1979, which is the specific period that we're looking at. So neither Mr. Krause's testimony nor Mr. Cohen's testimony creates an issue of fact, actually, as to whether or not any brakes were sold by any other supplier during the pertinent time period. So for those reasons, we submit that the trial court was incorrect. There certainly was evidence. We created an evidentiary link between Carlisle, sales from Carlisle to Mac, and sales from Mac to the Smith family at Laurel Hill Diesel. That satisfied our burden, and we were not required to prove a negative, which is what Carlisle suggests, that we were required to prove that none of the other authorized suppliers sold brakes during that pertinent time period. And even though we were not required to prove that, the evidence does not support the conclusion that any other supplier, authorized or otherwise, actually sold any brakes to Mac during the pertinent time period. The second issue, the second error that the trial court made was procedural. The trial court violated the brand new specificity requirement in Rule 1.510. So in 2021, Rule 1.510, which is Florida's summary judgment rule, essentially incorporated the federal standard, with one exception. While the federal standard for summary judgment, which is Rule 56, suggests that trial courts—
I'm sorry to do this, but could we backtrack to the time period? I understood from the appellee's brief that the ratio of Carlisle to the other manufacturers that supplied asbestos-lined brakes to Mac was either 1 in 3 or possibly up to 1 in 15.
No.
So your argument is there is no evidence of any other supplier to Mac from 75 to 7, at least from 75 you're saying now, to 79?
Well, I submit from 74 to 79,
Okay.
But even if we take, for the sake of argument, 74 as showing actual sales, which I don't think you even have that in 74, Carlisle's argument is that one's status as an authorized supplier is synonymous with evidence of sales occurring. I could be an authorized supplier to the First District Court of Appeal of whatever product I might sell, but if the First District Court of Appeal never buys my product, then I never actually sold.
Okay, so if there is an authorized supplier of asbestos-lined brakes to Mac, whether it's 3 authorized, including Carlisle, or 15, you're saying a jury couldn't determine from that, just looking at that in isolation, that one of those suppliers sold brakes to Mac?
I believe that would be entirely speculative. Like, certainly the plaintiff couldn't survive summary judgment with that same showing. If we just simply established that Carlisle was an authorized supplier during the pertinent time period, we could not survive summary
And
judgment.
you have proved Carlisle did so.
Yes. Mr. Creamer, who's Carlisle's corporate representative, definitively testified, and it's the only testimony in this record of any actual sales taking place. He definitively testified that from the years 1974 to 1979, Carlisle continuously sold asbestos-containing brakes, and exclusively asbestos-containing brakes, to MAC. And those are the same years of...
So your argument is essentially, let's say you survived the motion for summary judgment, and the appellees attempt to present evidence that, well, these other manufacturers were authorized suppliers. That would be inadmissible?
It wouldn't be inadmissible, but you would need additional evidence to call into question our evidentiary showing and then create an issue.
Well, let me ask you this. So if it's admissible that there were other authorized suppliers, let's look at it in the light most favorable to you. Only three, Carlisle and two others. So it goes to the jury, and during closing arguments, you're going to argue to the jury, look, we proved by preponderance of the evidence, because we are the only, our evidence regarding Carlisle, which is definitive, whether they can attack that some other way, I'm not sure, but you have a 100% link. You're saying they couldn't argue the odds are 33%, 1 in 3 to the jury?
No, and this goes, I believe the court's referring to the standard for circumstantial evidence. So if the...
Well, I think when you, correct me if I'm wrong, but on summary judgment, don't we sort of look at it in a similar fashion to a motion for directed verdict?
Yes, now with the adoption of rule of the federal
So
summary
let's say
judgment-
that's the evidence in front of the jury. Carlisle, your guy says, excuse me, your witness testifies that, okay, yes, we sold those brakes to MAC during that time period. There are two other witnesses of some sort that state we were an authorized supplier of brakes to MAC. Do you know for a fact that you sold brakes? No, I don't. But we did sell brakes, and we were an authorized supplier to MAC. Isn't that, at best, looking at it like most favorable to you, a 1 in 3 chance?
No, I don't believe so, Your Honor, because I think it's a 1 versus 0 chance. Stating that...
Well, you said it was admissible.
It's admissible, but that doesn't establish... It's admissible to show that they were authorized suppliers.
Right.
But without more, you don't get to the next step, which is showing evidence
So
of
are
sales.
you arguing that you would be entitled to a directed verdict on liability?
No, I mean, the jury could choose to not believe the testimony. I mean, that would go to credibility, perhaps. But we have established our burden of allowing the jury to make the finding. If they want to argue as a different supplier, they certainly can. But
Let me ask it this way. If there's sufficient evidence for a jury to conclude it could have been Carlisle, it could have been Bindex, it could have been one other manufacturer, do you survive a motion for directed verdict? I'm going to try it one more time. Isn't that indicative that there's a 1 in 3 chance, given, we're talking almost 50 years ago when this occurred, there's a 1 in 3 chance that Carlisle sold these brakes, and 1 in 3 is not going to survive your burden of proof.
But that would assume... Sorry, Your Honor.
Go ahead.
That would assume that the weight of the evidence or the quality of the evidence were the same as to all three. Again, ours is different because we actually have evidence of sales, not simply the status of a defendant as an authorized supplier. I think that is a critical difference. And on this record so far, at the summary judgment stage, the only permissible finding that a finder of fact could make, or could choose not to make, but could make as far as actual sales from an authorized supplier to MAC, is that Carlisle, because there is evidence of sales. One's status as an authorized supplier is not tantamount to evidence that supplier actually sold products to MAC.
But you're not going to argue you'd be entitled to a directed verdict simply because the
No, sir.
status testimony. Okay.
So again, turning back to the specificity issue, the trial court, aside from incorporating or repeating the typical summary judgment burden shifting standard, it dedicated one single line to its analysis, if you can call it that. It essentially articulated its conclusion that the plaintiff failed to establish this product identification requirement. It said, quote, there was no evidence, testimonial or otherwise, that the decedent Joan Smith was ever exposed to asbestos from any Carlisle product. We have no idea why the trial court reached that determination. So, notably, we actually showed the trial court the evidence, and it didn't state that the evidence was not sufficient or the probabilities were at best evenly balanced. There are certain underlying holdings that were necessarily made.
Did you move for rehearing on the basis the order was insufficiently specific?
No, Your Honor, and that's not a requirement for preservation. So I see I'm running into my rebuttal time. The last thing I'll mention is that Carlisle essentially argues that it was harmless error. If the specificity requirement was violated, it was harmless error because the court can simply look to the summary judgment
But
briefing.
you're mainly relying on your first argument, right?
Yes, Your Honor.
Thank you. You're in your rebuttal time.
Thank you.
You may proceed.
Good afternoon. May it please the Court. Mary Street on behalf of Appellee Carlisle Industrial Break and Friction. Thank you, first of all, for rescheduling this from January. I really appreciate the professional and personal courtesy to me. So I'm going to work backwards. I'm going to briefly address the procedural argument, which...
I'd rather you not.
Okay.
Let's start with the substance,
Great.
if you don't mind.
Perfect, Judge, thank you. So substantively, our position is not that plaintiff needed to prove a negative. Our position is plaintiff needed to prove their case. And as Judge Thomas pointed out, the standard is a directed verdict standard. So we need to look at what was the evidence in this record, and based on that evidence, could a reasonable jury find in favor of plaintiff? And because the plaintiff could not prove causation, could not prove that it was the Carlisle product that caused the damage, the
So
exposure
you
to Mr.
disagree with
Smith.
his characterization that the evidence regarding the other manufacturers was based on status, not on any testimony that they actually delivered asbestos line breaks to MAC?
So the evidence in the record, I think that plaintiff is misreading and mischaracterizing the evidence in the record about who was actually selling and supplying these brake linings to MAC. So if you look at, Judge Norby pointed out one of the most direct ones, which was Mr. Krause testifying specifically in 1974, Abex, Ray Bestos, and Carlisle were suppliers. And to me, a plain English understanding of what that means is they provided the brake linings to MAC for these trucks in 1974. Then, if you look at in the context of everything else, the other testimony from other MAC corporate representatives, they were asked by plaintiff's counsel. This is the question from plaintiff's counsel to Mr. Hinderleiter. And Carlisle, along with Abex, was one of your brake vendors, correct? And he says Carlisle and Abex were certainly manufactured for friction material over time. And then later, plaintiff's counsel again, who else supplied friction materials to MAC in the 1970s time period besides Carlisle and Abex? And Mr. Hinderleiter answers, I am not sure if I can characterize in the 70s the others, but that is me paraphrasing. But certainly we had Porter over time, Abex, Eaton, Rockwell. Those are the suppliers at times and others. So the part of this case that has been mind-boggling to me is plaintiff's counsel asked that question. So at some point in time during Mr. Hinderleiter's deposition, plaintiff's counsel understood and also believed that there was more than just Carlisle providing friction material to MAC in the 1970s. Abex was one of them. And it's not that there's no way that plaintiff could have proven their case against Carlisle. They have two brake blocks that turned out from their expert was able to determine were Abex brakes from the 1980s. And there are other ways that it could have been proven.
So what we have here is evidence that Carlisle sold asbestos line brakes to MAC during the relevant time period, right?
If I can, Your
Yeah, I
Honor.
want to go step by step, if you will.
Yeah, let's do this.
So-
If we go back, if we take a bigger picture, because we're focusing on, first it was 1974 to 79, and now it's shifted a little bit to 75 to 78, whatever. The reason for that is this. The plaintiff alleged exposure to asbestos from brake linings from 1969 through 1996 against 25-plus different defendants, Carlisle being one of them. Mr. Creamer, Carlisle's corporate representative, established that Carlisle didn't start selling to MAC until 1974. So necessarily, although we maybe don't know who, there was some other provider selling, supplying, however you want to say it, authorized or not, to providing these brake linings to MAC before 1974. We then have the testimony of Mr. Krause nailing three, like Raybestos, Abex, and Carlisle in 1974, and we have Abex in 1980. So essentially what plaintiff is asking the jury to do and this court to do is to ignore all of that evidence and assume that for some reason, where there is no factual basis for this, that MAC had one or more other suppliers other than Carlisle pre-1974 and one or more other than Carlisle post-1979, but for some reason, again, without any evidence in this record, only received brake linings from Carlisle from 1975 to 1978. And in 1979, that's when Carlisle's corporate rep testified that they went asbestos-free. That's why that end period has been tagged by plaintiff.
But I'm assuming, and correct me if I'm wrong, I'm assuming that the argument is you can get mesothelioma or other diseases from asbestos in 3 or 4 or 5 years. Is that right? So she could have contracted a disease from the asbestos between 74 and 79.
Right, and that's a different type, sort of, we're not.
We're not dealing with
yeah.
that, right, okay.
Right.
So we're strictly dealing with causation on, okay.
Placing the product in,
Yeah, let me try it this way. So from 74 to 79, we know Carlisle provided brakes, or correct. We also know, based on, I'll just go with your recitation for now, that 2 or 3 other manufacturers in that period, Bendex, I thought it was, or maybe some
it
others.
was Abex and Raybestos, but that's
Okay,
the,
thank you.
Mr.
So
Krause's testimony.
let's say then, at trial, assuming plaintiff's argument is going to be, my expert witness is going to testify that the decedent could have contracted the disease in those years. And in those years, Carlisle provided the asbestos-lined brakes, and assume that plaintiff will concede at trial, as did others. However, the jury, can find that we have more concrete evidence of Carlisle than any other manufacturer.
Okay. So the answer to that is, it just as plaintiff's counsel accused us of speculating that Carlisle did not supply, that Carlisle was the, hold on.
One of several.
Well, so of the approved suppliers that they're speculating or want the jury to speculate that it was only Carlisle supplying the brakes in that time period. And there's no, the
Well, he
evidence.
just said that's not what his argument is. Now, you can correct him if it gets to that point. But the argument is, yes, you have some evidence of other suppliers,
Right.
but I assume he's going to try to argue or claim he would argue that it's more likely than not they were Carlisle brakes.
But it isn't, because like you said, there are 2 others known for sure in the record at least, and up to 11 others, 13 others, that it could have been. So there's no proof, unlike Abex, where they have the brake and an expert that was able to trace it back. Unlike there is evidence.
Well, there's some proof it was Carlisle, right?
Apologies?
There's some proof it was Carlisle.
No, that's the thing. So we know that Carlisle sold to MAC, but we don't know that the MAC brakes that Mr. Smith was exposed to were from Carlisle. They could have been from Abex, Raybestos, or any of the others. And plaintiff's counsel is taking issue with this approved supplier versus not. And I am saying, I understand, I'm not arguing that all 13, 14, 15 approved suppliers were supplying necessarily at the same time. The point is, we don't know, but what we do know is that there was more than Carlisle in the 1970s, and plaintiffs did not prove and cannot show that it was only Carlisle in this relevant time period. Therefore, the jury would have to guess or speculate, and like the trial.
But is there a
court-
legal burden of persuasion to show that it was only Carlisle?
No, well, on this record, that is a way that they could have corralled the circumstantial evidence to do it, but because they can't, because there is no exclusive supplier agreement for this
No, my
time
question
period.
is there a burden to show that it was only Carlisle?
Not in every case, but on this record, they would have to, because they don't have the break, because they don't have a photo of the lining with a number that they can trace back to Carlisle, because they don't have somebody identifying the product. What I had written in my brief was, yes, Carlisle's corporate rep said that they exclusively provided asbestos-containing products in this time period to MAC, but what plaintiffs don't have evidence of is that it was only Carlisle providing asbestos-containing products to MAC in this time period, and that's where they fail on causation, because the evidence is the opposite. The evidence is there were at least 2 others, up to 15 others. And then it's asking and inviting the jury to speculate about whose product actually injured Mr. and Mrs. Smith. It's almost as if, like I said, it's as the other defendants in the case progressed, that plaintiffs sort of realized this failure of proof and have focused on this semantic difference between an authorized supplier and an actual supplier. But the fact is, they can't prove that the other ones were not actual suppliers or it was only Carlisle, because they can't show that the breaks in that time period were from Carlisle. That's the evidentiary gap that they have, and that's why the judge entered summary judgment in Carlisle's favor. And in the order, he cited Reeves, which is it was a product liability action, and in there it was similar, where you could assume that there was some evidence to show that it was the defendant's product, and some evidence that maybe it wasn't. It was from another, and because it was at best evenly balanced here, like you said, it's actually not even. It's a third, a third, a third. And it would defy logic and ask the jury to have just stacking inferences to say, for some reason that there's no evidence of, only Carlisle was providing these asbestos-containing linings to MAC from 1974 or 5, if you want to change it now, to 1979. And I want to point out one more factual issue. Let me turn to it. I apologize. So from the other MAC corporate representative, it wasn't just, oh, we have no idea. There was a MAC corporate representative who actually had evidence of sales. I apologize. Let me see if I have a better citation for you. Yes, so it was Thomas Brown, and it's in record 3506. And the question was, for brakes, we talked about Carlisle as a supplier of brake linings. Were there any other suppliers of brake linings in the 60s or 70s, to your knowledge, other than Carlisle? And that was plaintiff's counsel's question to Mr. Brown. The answer was Avex, Ray Bestos, Manhattan. So the 2 others from 1974. And again, this question was about 60s or 70s. And he says, I've actually gone from a vehicle identification number back to a specific lining that was on a specific truck and found those. So there's evidence in this record that plaintiff's counsel at the trial level and in the briefs kept saying there's no evidence other than, no evidence that brake linings came from anybody but Carlisle, but that's not true. We have evidence in this record that they came from Avex and Ray Bestos, Manhattan, definitively. And this is tracing it back to, it's a MAC representative tracing it back based on specific linings on a specific truck. It's not even, some nebulous corporate record. And so for that reason, there's no evidentiary basis or no competent substantial evidence that this jury could find it was Carlisle's product that injured the plaintiff in this case. And for those reasons, this court should affirm the summary judgment, because as you saw, the judge was, it was.
And I didn't mean to cut you off completely. If you wish to address issue 2.
Well, if you have any more questions, I'd love to answer them. But I do feel like that on this record, like I said, between the corporate representatives of MAC, all 3 of them taken together, plus, what I just read to you as well, even if plaintiff comes back and argues, well, the question said 60s or 70s, not 60s and 70s, and tries to do another semantic game here, we know from Mr. Creamer that Carlisle only started providing the brake linings to Mack in 1974. So again, we have there, if you look at the 75-foot view or 20,000-foot view of this case, the fact is that plaintiffs do not have evidence to show that it was Carlisle's product. And the reason for that is because, like I said, they don't have the product identification. The circumstantial evidence is lacking because
I guess a better way to put it, your argument might be they don't have legally sufficient evidence. There is some evidence.
correct, but some is not enough. It's not,
Right.
it's not enough to prove that it was possibly Carlisle. They have to prove that it was probably. And that's where you get to that question about the 33. I mean, it could be 1%, it could be, but it's certainly not, there's not enough evidence to say more likely than not it was Carlisle's product, because the evidence shows that there were at least 2, if not 15, possible suppliers of these brake linings at the relevant time period. And again, I wasn't saying that they had to prove a negative about the exclusivity. That was me pointing out that based on this record, that is a way that they could have proven their case against Carlisle. They could have had some contract between Carlisle and Mack to show, look, they were really the only ones. It doesn't matter that they had 13 other approved for whatever reason they entered this agreement and it was just Carlisle. But we don't have that. And we don't have, it would be a different story if we had the Mack corporate representative saying, oh, I went back to brake linings in the 70s and I can only find Carlisle ones. Then maybe they have a case. But no, it's Ray Bestos and ABEX. And we have the other one, like Your Honor pointed out, point blank, 1974, the suppliers were these 3. This jury can't ask, it is asking them to speculate to find otherwise. And so the trial court judge was correct. And this is a case that, this is what the new summary judgment standard was for, like Your Honor pointed out, to look at it like a directed verdict. What would a jury have in front of them to make a decision on? And there isn't a reasonable basis for them to conclude that more likely than not it was Carlisle that caused these damages. So if there are no other questions, I would ask that you please affirm on both substantive and procedural grounds the trial court's order granting Carlisle's motion for summary judgment.
Thank you.
Thank you.
Thank you, Your Honor. So appellee's counsel is very perceptive. She noted that. I would probably come back up here and state, well, the testimony was at some point in the 1960s or 1970s. Cannot get more speculative than that. That's a 2-decade time period versus the very concrete, narrow window we're talking about here, 1974 to 1979. Every time a Mack corporate representative was asked, be specific, they said, we don't know when. 60s or 70s, that's a long time. We have concrete evidence of Carlisle actually making sales from 1974 to 1979, and no evidence of any other supplier, authorized or otherwise, making any sales from them to Mack during that particular time period. And even granted, if in 1974 there was evidence of ABEX and Ray Bestos, which I submit there was not, but even if there were, you still have, again, 1975 to 1979. During those particular years, there's no evidence even arguably suggesting that actual sales took place from an authorized supplier to Mack. Appellee's counsel states that there's no reason in this record to doubt that other authorized suppliers were actually making sales during this time period. The record says otherwise. The whole point of Mack's testimony was we don't know. There's a bunch of authorized suppliers, and we don't know which of them was making sales when. That's Mack stating that, so it's not something that we're making up. The record repeatedly shows in every single interrogatory response that was part of the record and every single time that a Mack corporate representative was deposed, they all said that just because somebody's a supplier doesn't mean that they were actually supplying. And that's why we're trying to nail down. So when do you know? And they said, we don't know. The closest that they come is 1974. Mr. Krause does name 3 particular ones for one particular year as being quote-unquote suppliers. Even assuming that that establishes a 1 in 3 chance in that year, you don't have a 1 in 3 chance from 1975 to 1979. During those years, you still have exclusively Carlisle. You still have evidence. You only have evidence of Carlisle actually making sales from 1975 to 1979. The appellee suggests that they're not arguing we had to prove a negative. yet they repeatedly argue that we had to prove a negative. That is not our burden as a plaintiff. Our burden is to offer evidence to the jury from which they could conclude that this was a Carlisle
So your
product.
argument is, at closing argument, or at a DV motion, the fact that there's evidence that 15 suppliers, or however many it is, supplied brake linings in the 60s and 70s, and Carlisle supplied it from 74 to 79, that is enough to survive a motion against you for a directed verdict?
Yes, Your Honor. That is enough. That is competent substantial evidence from which the jury could conclude that during the pertinent time period, it was a Carlisle brake that produced the asbestos that Mr. Smith took home with him that eventually made its way into Mrs. Smith's lungs. That is sufficient evidence for the jury to make that finding.
Let me ask a science question, maybe belatedly. Can you get this from just a single exposure, possibly? Does it take years and years and years of exposure?
That's the subject of intense debate in the case law and in the science community. The general consensus is that one exposure, single exposure, is not sufficient to cause the disease, but it doesn't take much, and that is what is unanimous among experts. Some experts have testified that there's a minimum threshold of, say, 2 hours or 2 brake jobs, but that's not an issue in this case. But
I mean, the time periods you're talking about, 75 to 79, would certainly be, I mean, even a few months of that would
Oh, certainly,
scientifically be
yes.
sufficient to have caused.
Yeah, I mean, the general consensus is one single exposure is not likely to cause it, but beyond that, there's intense disagreement, but our experts typically say about 2 hours of exposure is sufficient and it doesn't have to be the cause. It can be a substantial contributing cause.
Sounds like a jury question.
Exactly. So for these reasons, Your Honor, we ask that the court reverse the entry of summary judgment and remand for trial. Thank you.
All rise.
Had not thought that through. Had not thought that through. There's a several hour gap now. 2:40. Our flight takes off in 5.5 hours. Doing sightseeing?
Yeah. Promised.
Tallahassee Airport's not nearly.
No, I don't think so. I think we should do something else